Hello friends, I welcome you all to lecture number 7 of Family Law Clat lecture series sponsored by Shri Jendra Rank Zone. I am your mentor Shekhar Gehlot. Now we are done with most part of Muslim law. We'll go to another part that is called Meher or a dower. Meher or dower, and the nature of meher or dower is a debt. It's a debt. Debt on whom? It's a debt. Debt means you have to pay back, okay, to the wife or wife's family. That is called meher or meher and dower. Okay, let us see what is meher and dower all about. The word meher is related to Hebrew word mohar and the Syriac word mahra, meaning bridal gift. Okay, meaning bridal gift, which originally meant purchase money. Now we call it bridal gift, but originally it meant a purchase money. Meher was already mandatory according to Eastern Roman law and was customary in pre Islamic Arabia as well. In Islamic law, Mahr is a mandatory payment. It's a mandatory payment, it's not obligatory. You cannot say no to it. Okay, you have to, it's must. Mandatory payment in the form of money or possessions. Either you pay money or possessions like land, animals, and something gold, jewelry, etc. Paid, either you paid at the time of marriage or promised by the groom or by groom's father to the bride at the time of marriage. Okay, either by groom himself or his father. Meher is typically specified in the marriage contract and signed during the Islamic marriage. Okay, it is a condition of marriage contract without which marriage will be batil or void. It will be a batil or void marriage. Meher is often money, but it can also be anything agreed upon by the bride, such as jewelry, home goods, furniture, dwelling, or some land. Okay, dwelling means residential house or some land. It is the duty of husband to pay mahr as per Quran Surah Al-Nisa for subclause 20, subclause 24. Okay, for subclause 20 to 24. Mahr is the bride's legal property. Okay, that is bride's legal property and establishes her financially independent from her parents and in many cases from her husband who has no legal claim to wife's mahr. Mahr is wife's own property. No one, neither husband nor father-in-law, mother-in-law, nor her parents can have claim over this property. The wife is entitled to mahr even if one of the spouse died before consummation of marriage but after nikah. Like suppose before consummation, before sexual intercourse, wife has died, then also she will be entitled to mahr. Mahr will go to her parents. Or if the husband dies before sexual intercourse, then husband's family will pay mahr to wife. Wife may refuse to cohabit with the husband if dower is not paid, if marriage is not already consummated. If sexual intercourse has not taken place, then wife can refuse to have it with the husband till the time money, that is purchase money or the bride money, is not paid. Wife can also sue the husband, okay, for recovery of mahar. Sue the husband or heirs or deceased husband. Either she can sue husband or husband's father, mother, brother, son, daughter, etc. for recovery of mahar. Under Islamic law, there is no concept of marital property. In Islam, marriage is a contract between man and his wives. A Muslim man and woman do not merge their legal identity upon marriage. The assets of man before the marriage and earned after marriage remain his during marriage and in case of divorce. Okay, if divorce is there, wife can have no claim over the wealth. Okay, wife can have no claim over the wealth of the husband upon divorce. Likewise, divorce does not require redistribution of property, with each spouse walking away from the marriage with his or her individual property. Whatever they have, they will carry off. Mahar versus dower. Dower in English customs refers to the payment from the husband or his family to wife. Dower in English customs. Some English families also follow this custom of dower. Christians follow this custom of dower, that is purchase money of wife. Okay, payment of husband or his family to wife, especially to support her in the event of his death. However, meher is distinct from dower in two ways. But this meher or dower, which is paid in Christian societies, and meher, which is in Islamic societies, they are different from each other in some ways. Meher is legally required for all Islamic marriages, while dower is or was optional. Dower has always been and it is still optional in Christian marriages. But meher is a legal requirement, a mandatory requirement without which the marriage is going to be a batil marriage or a void marriage. Meher is required to be specified at the time of marriage when a certain amount is promised if not paid immediately, while dower is not paid until the death of the husband. Dower is paid in the Christian society only upon the death of the husband. If wife dies before the husband, no dower left to be paid. But meher is specified, it is specific before the marriage, at the time of marriage. You may pay it later, but it is specifically mentioned. If husband divorces the wife, wife keeps the meher. If wife initiates a divorce for any acceptable cause such as husband's abuse, illness, impotency or infidelity, the woman has right to keep the meher. But if wife has left the husband without any reason, then wife is not entitled to take meher at all. If the wife seeks divorce outside generally accepted cause, the husband may request the return of mahr. According to Hanafi school, if woman initiates a divorce, she cannot receive her mahr regardless of the circumstances. In Hanafi school, it is if it is the wife who is initiating divorce, she cannot claim mahr, whether she is claiming divorce by illegal grounds or legal grounds. It hardly makes a difference in Hanafi school. There is no hard and fast rule regarding the quantum of mahr. What should be the amount of mahr? How big mahr should be? What is the quantum of mahr? There is no hard and fast rule. Okay. According to hadith, but one hadith says Muhammad stated that mahr should be one gold piece. Okay, one gold piece. Proper dower. What is proper dower? When amount of mahr is not fixed or specified in the marriage contract, wife is entitled to proper dower. The court can fix the quantum if somehow mahr is not fixed in the marriage. Okay, but it is written that we will give the dower, we will give the mahr, but how much mahr is not fixed. The court can fix the quantum of proper dower based on the qualification, age, and beauty of wife, social position of the family. Dower given to father, sister under Shia law, maximum amount of proper dower is 500 dirhams. 500 dirhams is maximum amount of dower which can be paid to a women. Okay. So 500 dirham today is equal to 10,000 rupees. So according to Shia law, maximum dower which could be paid to a wife is 10,000 rupees if it is not already decided. Okay. Prohibited relationship. Mahrims. Mahrim. They are called mahrims. These are prohibited relationship in which one cannot marry. Mahrim refers to a specific legal relationship that regulates marriage and other aspects of life. A mahram is an unbreakable kin, unmarriageable kin. Kin means relative. Relative which is unmarriageable, with whom sexual intercourse is incestuous. That means it will amount to incest. It will amount to incest. That means sexual relation between sibling and a punishable taboo and a punishable act as well. The following are the category of male mahrams for a woman. Okay, these are the males whom a woman cannot marry. Permanent or blood. Mahram with whom one is a mahram by a blood relationship. Okay, parent, grandparent, further ancestors, siblings, children, grandchildren, further descendants, siblings, parents, grandparents, etc. Okay, so who share blood with you? Grandparent, granddaughter, grandchildren. Okay, grandchildren, granddaughter, parent, or brother, sister. A woman cannot marry these people. In law marham, with whom one becomes marham by marrying father-in-law, mother-in-law, son-in-law, daughter-in-law, etc. Stepmother, stepfather. A women cannot marry these people. Radha or milk suckling marham, that is also called foster age, like we discussed, with whom one becomes marham because of being nursed by the same woman. If two people are nursed by the same woman, okay, two people are breastfed by the same woman, one male and one female, they have taken the breast milk of same women, they cannot marry. For a man, mahram women include his mother, grandmother, daughter, granddaughter, sister, aunt, grandaunt, niece, grandniece, his father's wife, his father's daughter, his wife's daughter, etc. Okay. Divorce. All other relatives they can marry. Divorce, talaq, and other forms. Okay, now how divorce happens in Muslim societies? Talaq is called divorce. Talaq is the name of the divorce. Talaq is the Urdu word for divorce. In its literal meaning, it means setting free or letting loose. Okay, it means setting free or letting loose. In Muslim law, it means freedom from bondage of marriage. It means freedom from bondage of marriage. The Prophet declared that among the things which have been permitted by law, divorce is the worst and should be avoided as far as possible. But in some occasions, this evil becomes a necessity. Like Prophet said that a Muhammad Muslim should never divorce his wife, and this is one of the biggest evil in the society. But sometimes it is required, then it can be done. Okay. The basis of divorce in Islamic law is the inability of the spouses to live together rather than any specific cause or guilt of a party, on account of which the parties cannot live together. Okay, any inability due to which they cannot live together can be a ground for divorce. Under Muslim law, divorce, talaq, may take place by the act of the parties themselves or by the decree of court of law. Either by the act of parties, divorce can take place, or by a decree of court of law. Okay, but they do not require any specific reason. Like in Hindu law, we had some 11 reasons. Okay, but here no such reasons are required. Now, divorce can happen either by husband or by wife. Now, what is the requirements or what type of divorce a husband can give? A husband may divorce his wife by repudiating the marriage without giving any reason. Okay, husband is not required to give any reason. He can simply call off a marriage. The proclamation of talaq can be at whim of husband. he can proclaim talaq whenever he wishes to, even in the absence of wife and without presence of any witness. Even in the absence of wife, if he says talaq, 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 talaq will be final. Okay, witnesses are also not required. Types of talaq. Now, how many types of talaq Muslim law allows? Talaq sunnah. Talaq is sunnah. Talaq in accordance with the dictates of the Prophet. Okay. Talaq in accordance with dictates of the Prophet. Prophet said that talaq can be done by these ways. This is of two types. Talaq il sunnah has further two types of categories. One is talaq e hasan. Talaq e hasan, talaq e hasan. Talaq e hasan, which is most approved form of divorce, okay, in Muslim law. Single pronouncement of talaq made in between periods of two menstruations, okay, followed by abstinence from sexual intercourse during the period of iddat, okay. Single pronounced of talaq, okay, made in between two periods of menstruations, okay, and then you do not have any sexual intercourse during the period of iddat, period of purity. Okay, not applicable if wife has passed age of menstruation. Okay, it is marriage is not consummated or parties have been away for a long time. Okay, if the parties are away for a long time, or women has passed the age of menstruation, or marriage is not consummated, then this condition is not applicable. Okay, two menstruation condition is not applicable. Talaq can be revoked anytime before iddat comes to an end. Okay, talaq will be valid. You can revoke your talaq till the time she is observing iddat. The moment iddat comes to an end, the talaq will become irrevocable. You cannot take back your talaq. And if you again want to remarry her, she'll have to conduct a halala nikah, either explicitly or by resuming sexual intercourse. Either you say I take back my talaq, or you people have sexual intercourse, talaq will be revoked. Okay, during this period. Talaqi Hasan, less approved. This is less approved form of talaq. Husband is required to pronounce the formula of talaq three times during three successive periods of purity. Okay, that means three successive periods of purity. He has to pronounce talaq three times. Okay, between three successive periods of purity. That means three menstrual cycles will pass. One menstruation cycle will pass, he'll say talaq. After another menstruation cycle, he'll again say talaq. After another third menstruation cycle, he'll say talaq. Okay, if the wife has crossed the age of menstruation, each pronouncement is made after interval of 30 days. If wife has crossed the age of menstruation, she is not a menstruating woman, she is an aged woman. Now after each 30 days, that means in 90 days, talaq will be complete. When the third pronouncement is made, the talaq becomes final and it is irrevocable. It cannot be revoked. Now next form of talaq is talaqi biddat, also known as irrevocable talaq. That means this talaqi biddat, once given, it is irrevocable. It cannot be taken back. Okay, talaqi biddat is cannot be taken back. It is innovative form of talaq developed during the caliphate. Okay, it is of many forms. Talaqi biddat has many forms. Now two forms let's discuss. The triple talaq declaration of talaq made in period of purity, either in one sentence or in three. Either you say talaq, 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 or one say talaq three times. Just say talaq three. Okay, talaq three times, or say talaq, 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 and talaq will be complete. A single irrevocable pronouncement of divorce made in period of tuhur or even otherwise. Okay, this is a kind of talaq which was followed by Muslim law in India till 2019. In 2019, Indian government has banned this form of talaq and made it punishable. That means talaq-e-ibbat is no longer valid in India. If a husband is saying talaq three times to a wife, it won't be a valid form of divorce. There won't be any divorce, but yes, husband can definitely go to jail. Okay, but talaqs done before 2013, 2019, following this talaq-e-biddat are a valid talaq. Okay. Conditions for a valid talaq. Now, what are the conditions for a valid talaq? Mention. The word talaq must be expressly mentioned. Okay, you should clearly say talaq. Talaq should be expressly visible when you are saying it. And husband's intention of talaq should be clear. His intention should be clear. There is, however, no specific formula. There is no specific formula, and pronouncement of such words which signifies his attention to disown his wife is sufficient. Saying something which shows that he has an intention to give divorce and saying talaq is sufficient. The expression of talaq may be written, oral, or even through WhatsApp. Okay, talaq can happen through WhatsApp, through email, through a video, through an audio, orally, or in writing. Okay, it can happen either way, but just you have to mention that I'm giving divorce and I have an intention to give divorce. Talaq will be complete. Mention is mandatory. Capacity: husband should be of sound mind. Okay, husband who is giving talaq should be of sound mind, should not be unsound, and have attained puberty. He has attained the age of puberty, because before age of puberty he is a minor and these rights are with the father of the husband. But after puberty, he will get the right. His capacity to say pronounce talaq will be only when he is sound mind and he has attained puberty. If a husband is lunatic, then talaq pronounced by him during lucid interval, that is when he is of sound mind, is valid. However, when insane husband has no guardian, the qazi or a judge has the right to dissolve the marriage in the interest of such a husband. Person: the husband has to pronounce the talaq himself. He has to pronounce the talaq himself. A guardian cannot pronounce talaq on behalf of a minor husband. Okay, a guardian cannot pronounce talaq on behalf of a minor husband. Husband has to himself pronounce talaq. Free consent. Consent of the husband in pronouncing talaq must be free consent. He should not be compelled to say so. He should say so in his own free volition. However, in Hanafi law, a talaq pronouncement under compulsion, coercion, under influence, fraud, and voluntary intoxication is also valid and dissolves the marriage. All other schools of Sina and Shia jurisprudence require free consent. So, in Hanafi school, if someone is saying talaq under coercion, under compulsion, then the talaq is complete. If someone is intoxicated under alcohol influence, he is saying talaq, talaq is complete. Or someone has committed fraud, he says talaq, talaq is complete. Okay, in Hanafi school. But Shia, Sunni, other schools want free consent. Among the Sunnis, talaq may be express, implied, contingent, constructive, or even delegated. In Sunnis, talaq can be delegated as well. Okay, A can delegate his friend B to go and pronounce talaq on his behalf. B pronounces divorce is final. If B pronounces divorce is final, he can delegate his power to say talaq by someone. It can be expressed. You can say talaq, or it can be implied. You start living away with the wife, living away from the wife. Okay, and you show by your conduct, you show that you do not want to carry on with her as a husband wife. Talaq will be complete. Okay, contingent, that upon happening of certain event. Okay, suppose you say if you are not able to bear a child, there shall be talaq. If she is not able to become pregnant, talaq will be complete. Okay, so these are the kinds of talaq which can happen. In Sunnis, Shia recognize only express and delegated talaq. Shia says only you have to, it is express talaq. Either you say it himself or delegate it, or you delegate it to someone else. The one whom have you delegated this power, he will say it. But someone has to say. Other forms of divorce by a Muslim man. Okay, what are some other kinds of divorce a Muslim man can pronounce? Ila. In Ila, husband takes an oath not to have sexual intercourse with his wife, and following the oath, there is no sexual relations for a period of 4 months. He says that I'll not have any sexual intercourse with my wife from today onwards, and for 4 months, he does not indulge in any sexual intercourse with the wife. After the expiry of fourth month, the marriage dissolves irrevocably. Now the talaq is complete, irrevocable talaq is there. If there is sexual relation within these 4 months, ila is cancelled. Okay, it is revocable, but only till 4 months. If after 4 months, it is irrevocable. In Sunni law, divorce is automatic after end of 4 months. In Shia law, the wife is simply entitled to a judicial divorce after the end of 4 months. In Sunni law, after 4 months, divorce is final. But in Shia law, wife is required to take a declaration from the court as well. Zihar. Husband compares his wife with a woman within his prohibited relationship. Okay. He compares his wife, with someone whom he cannot have sex. okay, whom he cannot have sexual relations, such as mother or sister. He says that you are just from today onwards, you are like my mother or you are like my sister. Okay, that means he is now giving talaq. The husband would say that from today the wife is like his mother or sister. Following such comparison, husband does not cohabit with the wife for a period of 4 months. Okay, for a period of 4 months, then talaq will be complete. Sania Mirza married Shoaib Malik of Pakistan. But Shoaib Malik was already married to one Aisha of Hyderabad. Okay, so but though Muslim male can have more than one marriage, but Sania Mirza wanted that I can marry only if you will keep me as a wife. If you are having previous wife, you have to divorce. So Shoaib Malik was already married to one Aisha of Hyderabad, and there was a controversy because they are celebrities. So there was a controversy on TV. So on TV, Shoaib Malik on TV called Aisha like my Appa. Appa means sister. That she is like my Appa. Appa means sister. Okay, this is how he divorced Aisha. This is how divorce of Aisha and Shoaib Malik took place. He compared her with his sister, and then for 4 months they did not have any intercourse, so divorce was complete. Now this was a divorce by a wife. Okay, how a wife can give a divorce by husband. Now, what conditions a wife can divorce? Before 1939, a Muslim wife had no right to seek divorce except on the ground of. Before 1939, okay, what were the rights of the wife to seek divorce from husband? These were the grounds. Leon, false charge of adultery, insanity of husband, impotency of husband, divorce by mutual agreement, khula and mubarak, divorce by delegation, talaki tafweez. Okay, now, Dissolution of Muslim Marriage Act 1939. In 1939, we got a Dissolution of Muslim Marriage Act, okay, which lays down several other grounds on the basis of which a Muslim wife may get a divorce decree passed by the order of court. That means now certain additional grounds have been provided to the wife for seeking divorce. These grounds are still valid to her. Okay, they are pre 1939 grounds, but now 1939 Act has given some more grounds. Let us see what are these grounds. Firstly, if the husband levels false charges of unchastity or adultery against wife, then this amounts to character assassination, and the wife has got the right to ask for divorce on these grounds. Such is such a mode of divorce is called liya. Liya means when he's saying that wife is of character is bad, you are a bad character woman, you are having sexual intercourse with people outside the marriage and this and that, then this amounts to character assassination and she has a right to ask for divorce. But she cannot pronounce divorce. Let me make this clear. In Muslim law, wife has no right to pronounce talaq like husband. Wife cannot take talaq simply by saying talaq, talaq, talaq or something like this. She will have to approach either a court or a qazi. Okay, either a court or a qazi which will decide upon talaq. Okay, qazi or court will decide whether talaq is to be given to women or not, but she definitely certainly has no right like husband has just by saying talaq will be complete. No. Okay, so these are only rights, these are only grounds for seeking divorce. On these grounds she can seek divorce, but it is not that if something has happened she automatically can pronounce talaq or leave husband and she can be considered a divorce. This is not the case. She'll still have to legally take divorce. Khula, to draw or dig up. Okay, to draw or dig up, khula, or to take off, such as taking off one's clothes or garments. It is said that spouses are like clothes to each other, and when they take khula, each takes off his or her clothes, they get rid of each other. Wife will say, husband will say, my wife is like my clothes, I remove my clothes, so khula. Wife will say, husband is like my clothes, I am removing my clothes, so khula. I am getting rid of each other. Okay. Khula is an agreement between the spouses for dissolving the marriage in lieu of compensation paid by the wife. Compensation paid by the wife. Okay, if she wants to seek a divorce, she'll pay a compensation to the husband that I am giving you some money. Now you please give me divorce. Okay, that means she is trying to take divorce. She is trying to say to husband that you take divorce with me. Okay, you give divorce to me and I am willing to pay you some money for that. Okay, out of her property. The consideration can be anything. It can be anything. Usually it is mahar. She says, I will leave my mahar. The whole or part of it. Once the husband gives consent, it results in irrevocable divorce. The husband has no power of cancelling the khula on the ground that the consideration has not been paid. Later on, women may not pay. Okay, but husband cannot cancel the divorce by saying that she said I'll give you money, but she has not given the money. He can go to the court, but he cannot cancel the talaq. Talaq is final. He can go to the court and file a suit for claiming the amount, but definitely he cannot cancel the talaq. Mubarak. Mubarak is a variant of khula. It's a kind of khula. Okay, it's a different variation of khula talaq. Unlike khula, where the wife initiates the agreement for divorce, in Mubarak the proposal may emanate from either side. Okay, in khula, wife pays compensation and request husband to give divorce, but in this case, even husband can take divorce. In Mubarak, both the husband and the wife are happy to get rid of each other, and all the mutual rights and obligations come to an end. The Shias, the word Mubarak should be followed by the word talaq. Mubarak talaq. Okay, in Shia, if you want to give such talaq, you have to say Mubarak talaq. Okay, otherwise, no divorce would result. They also insist that the pronouncement must be in Arabic unless the parties are incapable of pronouncing the Arabic words. Mubarak is irrevocable both among Sunnis and Shias. This kind of talaq is irrevocable. You cannot take it back. If you want to remarry, wife will have to go through halala nikah. Talaqi tafwiz. Okay, talaqi tafwiz. Talaqi tafwiz or delegated divorce is recognized both by Sunnis and Shias. Okay, the Muslim husband is free to delegate his power of pronouncing divorce to his wife or to any other person. He can give this power to wife as well. That when you will say talaq, talaq will be complete. Then wife, if she wants to divorce, she can pronounce talaq and talaq will be complete. But only if the husband is giving her this power. If husband is delegating her power of talaq to wife, then only this divorce will come to end or any other person. Like he can give this power to wife's brother or wife's family member or his own friends. He may delegate the power absolutely or conditionally, temporarily or permanently, like for 1 year or permanently, absolutely or conditionally. A permanent delegation of power is revocable, but a temporary delegation of power is not. A permanent delegation is revocable. Okay, you say I give you power to say talaq whenever you want to forever life. You can take it back, you can take that delegation back. But a temporary that I give you for 1 month, and for that month you cannot take it back. Dissolution of Muslim Marriage Act 1939. Now, Dissolution of Muslim Marriage Act provides further grounds of divorce to wife other than these divorce which we discussed. Whereabouts of the husband not known for 4 years or more. Like in Hindu law, we have 7 years, they have 4 years or more. Court issues notice to all legal heirs of the missing husband and waits for 6 months for a person to reappear before granting divorce. Court will issue notice to all legal heirs that if any one of you know the husband or the father, you bring the husband of this woman back. If he does not come within 6 months, then divorce will be granted. When husband neglects or fails to provide for maintenance for a period of 2 years, for 2 years continuously he is not maintaining you. But if he is maintaining you once and before the completion of 2 years, in the end he is again maintaining you. And then for next 1.5 year he is not maintaining you. Okay, so 2 years means 24 months. So for 23 months he does not maintain you, but 24th month he provides you some money. And then next for 23 months he does not maintain you, 24th month he will again maintain you. So this kind of talaq will not be able to happen if such practice is followed, but in this, because in this continuous 2 years are required. Failure to provide owing to negligence or lack of means make no difference. However, wife should not be living separately without any reasonable excuse. But in such case, if wife is living separately without any reasonable excuse, then he is not required to maintain and she also cannot take divorce as well. Husband sentenced to imprisonment for the period of 7 years or more. The date sets in from the date on which the sentence becomes final. After all appeals are over. If a husband is sentenced to 7 years or more, okay, what is the relevant date? Relevant date is when the final appeal is over. Okay, if session court has said 7 years, then he will go to high court and to the Supreme Court. So when it will become final, okay, when Supreme Court says that 7 years, from that date, okay, he she can initiate divorce proceedings. Husband fails to perform without reasonable cause his conjugal obligations for a period of 3 years. For 3 years, he is not willing to have sexual intercourse with the wife for 3 years. Okay, then she can take divorce on this ground. Husband was important at the time of marriage and continues to be so. That at the time of marriage, husband was important and he is still important. Then also divorce can be taken by the wife. Husband is insane for a period of 2 years and is suffering from leprosy or virulent disease. Either the husband is unsound for 2 years or he is suffering from leprosy or virulent venereal disease, sexual disease. The period should be 2 or more years immediately preceding the presentation of suit. That means when you are filing the case, then immediate 2 years, okay? Immediate 2 years. Khiarul Bulug, option of puberty. If wife was given in marriage by her father or other guardian before she attained the age of 15 years, she can repudiate the marriage before attaining the age of 18 years, provided that marriage has not been consummated. But if they have had sexual relations, then this Khiarul Bulug is gone. Okay, this Khiarul Bulug is available only till the time they do not have sexual intercourse. Husband treats wife with cruelty. Cruelty, like we discussed, can be both mental as well as physical. Okay, so on these are the additional grounds to wife. Now we have been discussing a word called iddat a lot of times. Okay, but I kept it for some for this ending part so that we can understand what iddat is. Iddat is the time period before which a woman cannot have a second marriage. Okay, after the first marriage ends. Now iddat is a period.
It's 5 o'clock.
Iddat is a period which a woman is required. Suppose a woman is divorced, so she'll follow Iddat, and during the period of Iddat, she is not allowed to have any sexual activity either with the husband or any sexual partner, and she cannot have a marriage as well within the period of Iddat. Now, what is this period of Iddat? Let us see. The Iddat period is generally it is considered to be what? 3 menstrual courses if she is subjected to menstruation. Okay, 3 menstrual courses, so we can say 3 months. Okay, if she has menstruation. If she does not have menstruation, she is aged woman, she is not going through menstruation. 3 lunar months if she is not subject to menstruation. 3 lunar months, 3 lunar cycles. 3 lunar cycle means full moon to no moon, and then full moon to no moon, full moon to no moon. That is again 30 days. 90 days, sorry. This is 90 days, this is 90 days. The time period between her divorce and the delivery of child. If she is pregnant when it was given, she was given divorce. So if the child is due within next 8 months, then 8 month will be iddat. If within 1 month, then 1 month will be iddat. Or the termination of pregnancy, whichever is earlier, if she is pregnant at the time of divorce, or if she has terminated the pregnancy. Okay, if she has terminated the pregnancy, then her iddat will end with the termination of pregnancy. 4 lunar months and 10 days if marriage is dissolved by death of husband. Okay, this applies even if marriage is not consummated. Okay, even if they have not had sexual intercourse and the husband has died. Okay, okay, if the marriage is dissolved by the death of husband, then 4 lunar months, that means 4 months and 10 days. Um, 130 days we may say. Okay, 130 days we may say it will come out. Generally it is taken to be 3 months. Husband is bound to maintain the wife during period of iddat. During period of iddat, husband is liable to maintain wife.